Welcome everybody to Park Lane Plowden's Law with Lunch. Thank you all for coming. By way of introduction, my name is May Martin. And I'm joined by Bethan Davies. We're both specialist PI clinic barristers at Park Lane Plowden. The webinar today is the case law update for the biggest PI cases over the last 6 months or so. And we're going to be taking you through them, identifying the key points and the issues that you need to be aware of. We'll keep you for about 30 minutes. Very aware that this is taking place on people's lunch breaks. We don't want to deprive you of the full hour. So we'll keep you for 30 minutes and then we will let you go. The slides that you see today will be sent round to you after the webinar, and a recording will also be made available to you. So don't worry about writing things down or missing anything. If you do have any questions throughout the course of the webinar, if you put them in the chat box, once we've finished, Bethan and I will do our best to answer the questions that we can. And if there's any left over that we don't have time to get to, we can always answer those via email if that would be helpful. I'll hand over to Bethan. She's got the first set of cases for you, and I believe she's going to take you through some of the developments in costs.
Thank you, May. I'm going to start with 2 apologies. Firstly, sorry for talking to you on your lunch break about costs, everyone's least favourite subject. But my view is that it's better to get your CPD about costs, get some updates on your lunch break whilst you can sit and have a cup of coffee. Maybe might need something stronger when we get into some of these cost cases, rather than having to read them all yourselves. So hopefully you'll forgive me for being quite so boring. The second apology is that if I am joined by a very strange backing track today, it isn't a small animal being tortured. It is a small puppy downstairs, which has he's found his voice recently and is very keen to join in on this law with lunch. So apologies if there are some strange noises in the background. May, if you'd like to change the slide, thank you. I'm not going to take you through this whole list of 7 cases. I'm sure you'll all be grateful to hear, but there has been a flurry recently, specifically actually over the last sort of 2 months, of fairly interesting cost cases, if that's not an oxymoron in and of itself. I want to start by talking about Ho. I'm already breaking May's rules because actually Ho's not a development in the last 6 months. You'll all be aware that it was actually handed down in October of last year. And you're likely all exhausted of hearing about it. So I'm not going to rehash the background details. There have been various articles on each stage of Ho, in fact, on the Chamber's website, most recently by Abby Telford in October, if for whatever reason you still feel the need to go through Ho in great detail. However, what I found is since October, I've actually found myself instructed on 2 cost disputes, specifically arising out of the same misunderstanding or misreading of Ho. And that's a misunderstanding of Ho in essence, meaning that you can't offset costs against claimants' costs, and that's simply not the case. One of those misunderstandings meant that we were risking going before a judge and having a judge look at what were very generous agreed costs from a claimant who was a protected party, which had arisen from the late acceptance of a Part 36 offer in circumstances where in essence that late acceptance was because of a delay in getting medical information. So we were really risking, on the basis of a misreading of Ho, potentially losing some very generous agreed costs. So I thought it might be helpful just to remind ourselves. And really, it's paragraph 37 that you can see on the screen, which makes clear that Ho isn't about offsetting. See the italicised section of the paragraph. The defendant can recover the costs ordered by any means available, including set off against an opposing cost order, but only up to the monetary amount of the claimant's order for damages and interest. So now if we move to the second slide, what's clear is that Ho is not a determination that you cannot offset against the claimant's cost orders in quats cases. That's really putting the cart before the horse. It's conflating 2 stages. I think the best way to think about this process is to consider that there's 3 stages here. Stage A, and this is set out in paragraph 38 of the judgment, is calculating the aggregate amount of all costs orders in favour of the defendant. So basically, how much money is the defendant entitled to is question number 1. Stage B, again set out in detail at paragraph 38 of the judgment, is then to calculate the aggregate amount of all damages and interest that have been made in favour of the claimant, so i.e. how much money is the claimant entitled to. And that stage B gives us what I refer to as the pot for the purposes of enforcing a costs order. So if B is larger than A, if the pot of money from the claimant is larger than what the defendant is entitled to, then there isn't any issue for the defendant. All of the defendant's costs can be enforced. If B is smaller than A, so if the pot of damages and interest is smaller than the defendant's costs entitlement, then the enforcement of B, of the defendant's sums, is capped at the enforcement of A is capped at the value of B. So the enforcement is capped at the value of that pot. So once you've done that exercise, calculating what goes into the pot and whether there is a shortfall, whether you're capped at the pot, then you can consider enforcement. And at that stage, you are entitled to offset as a mode of enforcement against claimant's costs. Thank you. The problem here is, as I indicated at the outset, Ho was decided in October. And as I said, you're probably, hopefully, all well versed with it now, but there's a chance that that's going to change. Because just last month, the government published a consultation into qualified one-way cost shifting. And what that consultation makes clear is that the government is troubled with the outcome of Ho. Now, again, this confusion about the pot and set-off is in some ways imported into the government's publication because there are some slightly confusing and unhelpful references to set-off in the government's wording. But what is clear is that the government proposals are to potentially reverse Ho. And the proposals include the proposed changes set out in some detail to the relevant sections of the CPR. And the government's proposal in regards to CPR 44.14 is to expressly insert the word costs alongside damages and interest, i.e. costs being included in the pot. Obviously, as the proposals were only open for comment in May 2022, it remains open to responses. And of course, you'll all have differing views depending upon which side really you primarily work for. But the proposals raise some interesting points. There is a suggestion that in essence, a claimant who beats a Part 36 offer could potentially recover no costs if the defendant's costs exceed the aggregate damages, costs and entitlement to interest. And there is also reference to deemed cost orders in the case of Part 36. And the point there really is that deemed cost orders could have direct implications where, for instance, a Part 36 offer is accepted but out of time. That would allow a defendant to enforce set-off without the need to seek permission for the court in the case of out-of-time Part 36 offers. So they are very important proposals and ones that potentially are going to turn the situation on its head once again. Thank you. Next case I want to touch on is the case of Wooger and Hallis. In essence, the case involved a road traffic accident, liability was admitted, matter went to trial and the judge found that the claimant had been fundamentally dishonest under section 57, but at first instance applied the substantial injustice test. First instance judge awarded claimant some heads of damage on the basis of substantial injustice on, in essence, two reasons. Firstly, that part of the claim was genuine, and secondly, that others had provided past care and there would be substantial injustice to those who had provided past care not to award those losses. The judge, in essence, carved up parts of the claimant's case, so awarded those aspects, but declined to award damages in relation to loss of earnings and associated matters where it was found the claimant had been dishonest. The defendant appealed. And in essence, what we can see, if we just go back one slide, please. The case is some helpful guidance on the approach to section 57, albeit it doesn't answer all of the relevant questions, which I'll come to in a moment. But what was made clear is that if the starting point of section 57 is the loss of all damages, then the loss of all damages cannot be substantial injustice, because that would be a tautology. It would mean that every application of section 57 would therefore entitle a claimant to plead in aid of the exception. The fact that part of a claim is genuine, well, that doesn't get the claimant anywhere, because that would be contradictory to the plain purpose of section 57, which is ultimately punitive, it's ultimately punishing the dishonest claimant. Moreover, the fact that the others had provided past care and it would be substantial injustice for them not to receive, in essence, their compensation, was found to be flawed reasoning, because the substantial injustice for section 57 exceptions has to be to the claimant, not to others. That helps us understand what isn't substantial injustice. But what we can then see was determined, if we move on to the next slide, is that there wasn't much help on what is substantial injustice. Judge, in essence, declined to give any reasoning, concluding, if you just want to move to the next slide, at paragraph 49, that county court judges will generally know it when they see it. That puts us all in some slightly dodgy territory where we have to hope that our judge knows it when they see it. What is interesting is that the appeal didn't determine the question of whether section 57 gives judges the power to reduce claimants' damages in the way that they were done so in the first instance in this case, in essence carving up honest and dishonest aspects of the case, of the claim. The appeal judgment made clear that that's a question to be determined when it properly arises, which wasn't in this instance. But that raises an interesting point, because it appears would have been tentatively suggested that no such power arises, that in essence section 57 is an all or nothing. And that, of course, is consistent, again, with the notion of section 57 being punitive, and also without any sort of discretion in that regard. The next cost case I want to talk about is Malloy and others in UK Insurance Limited. Very briefly, the case pertained to a single RTA. As we often see, more than one individual in the car. There were two claimants for which two separate CNF claims notification forms were submitted. There was a single fixed costs fast track trial where the claimant succeeded. They both beat Part 36 offers, but the dispute related to what should happen to the fixed costs element under Table 6B of CPR 45. The issue was whether the claimants got two lots of those costs. Interestingly, the defendant did agree that the claimant should get two lots, or the claimants should get two lots of the 20% of damages that you see accounted for in Table 6B. And what was decided ultimately on a question of interpretation of the portal was that claim and claimant used within the portal have a specific meaning, and that specific meaning relates to a claim which has been started by a CNF. What the case made clear is in these circumstances, where you have two claimants and two CNFs, the claimants will be entitled each to their section 45 6B costs. However, what the judgment appears, seems difficult to argue otherwise, to indicate is that where the claims have been started with a single CNF, despite perhaps all the other circumstances being the same, two claimants, two sets of injuries, two sets of medical reports, in those circumstances where there's a single CNF, it appears that those two claimants would only be entitled to one set of 6B costs. And that rationale is somewhat difficult to square, because of course, if you have two claimants, regardless of the fact you may have had one CNF, you still broadly have two times or more work at the very least than you would with one claimant. But as a matter of construction, that appears to be the outcome of Malloy. So it's an important case for those doing claimant work. Make sure you're not just putting two people on one CNF, but also important for defendants to have a very careful look when you're getting a multiple claimant fast track trial to ensure that there are those two CNFs. And then lastly, I just want to touch briefly on the case of Guy. The case in hand concerned an application by the claimant for relief in connection to a breach of a court order by the defendant. The slightly strange situation in this case was that the defendant had in essence warned the claimant that they were going to breach a court order. The claimant had been aware of the same, and there were quite protracted negotiations, in essence the claimant trying to persuade the defendant not to breach the order. Unsurprisingly, the defendant did breach the order and then ultimately applied for relief from sanctions in regards to that breach. The claimant argued that they should be entitled to their costs that preceded the breach, i.e. the costs for that protracted negotiation period to try and persuade the defendant not to do so. And the court held that in essence the scope of the costs of an incidental to the application could pertain to the costs prior to the breach. And if we skip to the second slide, what the case reinforces is that costs incurred prior to a breach and an application can be recoverable as costs which are incidental. But it's important to be wary of the differences in language. And it's a subtle difference, but it's an important difference because this application pertained to costs which were of an incidental to, distinct from orders such as costs of and occasioned by. And there is a difference there because the prior of an incidental to is wider with a more expansive scope than the latter. So it's an important case for any PI practitioners, but certainly when you're in a circumstance of perhaps agreeing orders or giving instructions in regards to costs for applications, to consider the potential significant difference between those two formulations of what seem to be very similar costs orders. I promise not to be too long. I think I'm 3 minutes over. So on that basis, I'm going to hand you over to May for hopefully some slightly less dry information.
Thanks, Bethan. And thanks especially for agreeing to take the section of the talk that was costs, because it means that I get to talk about not costs, which I'm pretty happy about. So I'm going to cover two cases. The first of which you can see on the slide is Paul and Royal Wolverhampton NHS Trust. And it was a big case from the Court of Appeal, and it was dealing with the issue of when individuals who've suffered psychiatric injury, your classic secondary victims, can recover damages. Now, Paul was actually three claims in one, and we've got Paul, Mia, and Purchase. And I've put the very brief facts of them on the slide, but in effect, they're all claims with a clinical negligence background in that they involve a failure to diagnose an underlying medical condition, which then a year, 2 years down the line causes the collapse and death of an individual, which was witnessed by a family member in Paul and Purchase and by school staff in Mia. The family member who witnessed the collapse and death suffered psychiatric injury, not surprisingly, and then brought a claim against the NHS Trust, who had failed to diagnose the initial condition back 2 or 3 years ago. I want to go into the facts of Purchase a little bit more because they're particularly acute, and I think they're quite difficult to square with the reasoning that I'll come on to. But in terms of Purchase, the individual who was misdiagnosed was a 20-year-old called Evelyn. She visited her GP, and I'm going to emphasize the dates for reasons that will become clear, on 3 occasions. She visited at the end of January 2013, the end of March 2013, and also the 4th of April 2013. Her symptoms included general weakness, difficulty breathing, and she was given antibiotics and, surprisingly, antidepressants. 3 days later, after that last GP visit, on the 7th of April, Evelyn's mother returned home from an event and found Evelyn lying on her bed. She was staring at the ceiling. She wasn't moving. She wasn't blinking. So Evelyn's mother called 999 and was advised to give mouth to mouth. When Evelyn's mother opened Evelyn's mouth, blood spilled out, and her mother became increasingly aware that her attempts to resuscitate Evelyn were futile. Nevertheless, she carried on until the paramedics arrived. They also tried to resuscitate Evelyn, but it was unsuccessful. Shortly after that, Evelyn's mother checked her phone and realised she had a missed call from Evelyn from about 5 minutes before she'd found her. The phone call was just over 4 minutes long, and it was just the sounds of Evelyn dying. Now, after that whole event, Evelyn's mother suffered psychiatric injury and brought the claim. Now, the Court of Appeal struck all of them out. They said that there was a really fatal issue in the case, which was that there was a time lag between the defendant's negligence and the horrifying event, which would be the death of the individual. And I think the first question that springs to mind is, well, why should that matter? What difference does it make that there's a time lag between the negligence and the horrifying event? To answer that question, we have to go back to Alcock, and it's the case on secondary victims and psychiatric injury. And we know that it set out the 5 factors that must be present before you can recover damages for psychiatric injury. And I think, to be fair, Alcock is really where the problem started, in that it's a decision from 1992, and it's a difficult decision because it's set against the background of the Hillsborough disaster, in a situation where it comes through quite clearly in the judgments that the judges are concerned about not letting the scope of liability be too wide. So they're thinking of ways that they can keep this liability within manageable levels. And what they come up with are these 5 factors that have to be satisfied before you're able to recover. Now, in the case of Paul, the factors that really posed an issue were factors 3 and factors 5. 5 was dealt with in Paul fairly easily because the Court of Appeal simply held that the event meant the event which caused injury to the primary victim. So if we say that the event was the collapse and death, there's no issue in terms of there being a temporal connection. The thing that the Court of Appeal struggled more with was factor number 3, that the claimant had to be present at the scene of the accident. Because the question is, well, does the accident mean the negligence, or does the accident mean the event 2 years later when the primary victim dies? In the Court of Appeal, we see Sir Geoffrey Voss, the Master of the Rolls, say that he would be perfectly happy to say that the accident is the collapse and the death. And on that basis, he would have been perfectly happy to find the defendants liable in each of the 3 cases. That was very much his view. However, that wasn't the end of the story, because he, I think, despite his best efforts, found himself bound by the earlier Court of Appeal decision in Taylor and Novo. This was an incident where the defendant's negligence caused some racking boards to fall upon the claimant's mother. At the time, she suffered a minor head injury and a minor injury to her leg, but it didn't appear to be too serious. 3 weeks later, though, the claimant's mother developed a deep vein thrombosis and died of a pulmonary embolism, which her daughter witnessed. And the question was, despite that 3-week time lag, can the claimant recover damages in that situation? And what Lord Dyson said was no. He said that extending liability to cases like these would be extending it too far. It seemed to be something that concerned him greatly, that there could be claims brought in these types of cases 5 years, 6 years, 7 years after the original negligence. And he thought that that was stretching this idea of proximity beyond the limits that it should be kept at. The remarkable thing, in my view, though, from Taylor and Novo, it is in the quotes that I've put on the slide, in that it seems to be that when Lord Dyson was trying to figure out how far is too far, the primary thing that he's taken into account is how it would look to ordinary people. We can see that he couldn't really square the idea that if the claimant witnessed the mother's death 3 weeks later and could recover, but if she came across the accident, say, shortly after the immediate aftermath and couldn't recover, Lord Dyson thought that that would mean the ordinary person would think that the law is incomprehensible. It doesn't make any sense. But that, to me, is really remarkable, because it seems to be that he's saying the law is already a little bit unreasonable. So on that basis, I'm going to keep it where it is, and I'm not going to take any steps to extend that or possibly to remedy that. And it's also interesting, I think, because we don't see judges making decisions based on how they think it will look to other people. You know, we see them applying the principles that they've tracked through the case law, but here we've got a clear departure from that. And what's apparent from Paul is that Sir Geoffrey Voss is not happy about that. He looks at the factors from Alcock and he asks whether or not there should be liability in these situations. And he says there, I accept, although there is no logical reason for the decisions to be the way they are, he's bound by them. And so there's nothing he can do about it. What that is, though, there in paragraph 12, is as obvious an invitation as I've seen to the Supreme Court to have another look at this and possibly to overturn Taylor and Novo and to reverse the decision in Paul. Permission to appeal to the Supreme Court has been granted. There isn't yet a date for the hearing, but this is definitely a space to watch, because it seems to be that there will be fairly significant developments following the outcome of the Supreme Court decision. The second case that I want to talk about, and I'll go through it quicker because I can see I'm coming up to 1 o'clock already, it is Hughes and Ratton. This was a decision really about non-delegable duties. So it's a case about dentists. The claimant goes to a dental practice which is owned by the defendant, Dr. Ratton, but she's not treated by Dr. Ratton. She's treated instead by what are called self-employed associate dentists. She sees 3 or 4 different ones over her time at the practice. She doesn't get to pick which dentist she sees. In effect, she phones the practice, she asks for an appointment, she shows up on the day, and then whichever dentist she's been assigned to is the one that treats her on that day. The dentists treating the claimant did so negligently, and the claimant brings the claim against Dr. Ratton as the practice owner. She brings it, first of all, as a claim for vicarious liability, in effect saying that it doesn't matter that the dentists are not employed by Dr. Ratton because they're in a relationship akin to employment, and that's enough. There's no doubt that that is the test. The law seems to be fairly settled now following the Barclays Bank case of 2020. But what the Court of Appeal did was apply the law to the facts of Ratton and decide that there isn't quite that relationship akin to employment. There's nothing particularly groundbreaking here. But what is much more interesting is the claim that was brought in respect of a non-delegable duty. This idea of a non-delegable duty is one that was really developed in the case of Woodland. You'll probably be familiar with it, but it's a case involving a school pupil who has swimming lessons provided as part of her school education. The school takes her down to the local swimming pool, brings in an independent company who provide the teacher and the lifeguard, and says, there you go and learn front crawl. The swimming teacher and the lifeguard are negligent. They don't supervise the children appropriately, and the claimant suffers a brain injury. And the claimant brings the claim against the school on the basis that they owed her a non-delegable duty. And in Woodland, we get the 5 factors that need to be satisfied before such a duty will be owed. It's a strange idea, this idea of a non-delegable duty, in that it's holding somebody responsible for acts of negligence that they haven't done, on the basis really that there's this relationship between the defendant and the claimant that means the defendant is deemed to be responsible, even though they're not the ones actually performing the negligent acts. So we've got the factors there, and the key one for the claimant in Hughes and Ratton was the first one, that the claimant needs to be a patient or a child or dependent on the defendant's protection. Because what Dr. Ratton argued was that the claimant was not a patient of his. He said that she was not a patient of the practice. Instead, she was a patient of the individual dentist that treated her. The court in Hughes and Ratton gave that pretty short shrift. They looked at factors such as this concept that the claimant couldn't pick which dentist she wanted, and all of the forms that she'd signed setting out her treatment plans named Dr. Ratton and didn't name any other dentist. And when the claimant paid for the treatment, she paid the practice. She didn't pay the dentist individually. And a factor that I think was particularly key in the court's reasoning was that there were restrictive covenants in the contract between the dentist and Dr. Ratton. As soon as those dentists left the practice, they were prohibited for 12 months from contacting any customers or any patients of Dr. Ratton's practice, which the court said clearly shows that the dentists aren't the ones who have responsibility for the claimant. She's not their patient. She's very much linked to the practice and to Dr. Ratton. And so on that basis, the court held that there was a non-delegable duty owed. Now, the reason that it's an interesting decision is because it broadens the scope of liability quite a lot, in that lots of dental practices and lots of GP practices, we see these very complex structures between the GPs and the dentists and the practice themselves. And bringing a claim in vicarious liability is always difficult because you've got this question of, well, are they in a relationship akin to employment? Non-delegable duty, as we see here, goes much wider than that. There would be no vicarious liability, but that's fine because now the court's confirmed the claimant's got an alternative way to recover, which is to bring the claim and show that they can satisfy these 5 Woodland factors. So something to bear in mind if you are dealing with claims against GP practices or dental practices. If you think vicarious liability is not going to be an option, think about whether or not a claim relating to a non-delegable duty might allow you to recover in situations where you might not be able to otherwise. I would expect in the next few years to see cases testing the scope of exactly how wide this is. And because at the minute it seemed very wide, I imagine we might see it being restricted somewhat over the next few years. Right, that's covered the 2 cases that I wanted to deal with. I've had a quick look in the chat box and I can't see that there are any questions. So unless one pops in the next sort of 30 seconds, that brings today's webinar to an end. Bethan and I will leave you all to go and get some lunch. We will go and get some lunch ourselves. And as I say, the slides and the webinar will be sent to you so you can rewatch at your leisure. Thank you everybody for coming.
Thank you.